Welcome to this free immigration help channel. Today is June 25th, 2023, and we are getting into the volume 126 of me answering your immigration related questions. As you can see, I have all your comments pulled up in front of me today. As always, before beginning this video, I'm going to mention I am not an immigration attorney. This is not a legal advice. All the information provided in this video on this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first question, comment from Sagar Bamidipati 6910. Sorry about all the handles. YouTube decided to change, instead of names they're showing handles now. I don't know why they did it, but sorry about that. So let's start with a comment from Sagar. Actually, Sagar is Prem. Hi, my name is Prem. Hi Prem. With your suggestion, I have applied for visitor visa extension for my in-laws, which was in progress. Our case was received on April 20, 2023, and we have applied for visitor visa extension until June 30, 2023, using I-539 and I-539A. We have not received any update from USCIS yet. However, I would like to extend for 2 more months as my in-laws want to travel around US. Should I need to reapply again if we want to extend their visas until August 30, 2023? Thank you in advance. Prem, thank you very much for your comment, for your question. So the good news is that most likely you will not even need to bother submitting the whole other application package with I-539 and I-539A. Why? Because most of the times these I-539 applications are extended for 6 months. Even if you are asking for a 2 months extension, most of the times by default they give you a 6 months extension. So that's really good news. There isn't really any bad news, but one thing that I wanted to kind of bring to your attention so that you're aware of it is that as recently, I don't know why, but these I-539, they do take quite a long time to process, and in most cases it's about a year as of right now. As of at least the last time I checked the processing time for I-539 for most of the service centers, it takes about a year to process, which means that by the time you receive your decision on your I-539, it's going to be already basically expired, and when you receive that decision, your parents will have to go back to the country where they came from, which is not such a bad thing at all. The only kind of minor concern that you need to keep in mind is that you don't want them to leave before they receive the decision. It's very important to wait for that decision and only leave the country, the United States, after they receive the decision. Because if you leave the country while the I-539 is pending, it is considered abandoned, and you definitely don't want that to happen. Alrighty, so let me post the response here, and we're gonna move on to the next comment. Question from Shabana Khan 730. Hi sir, when people done documentary qualification, how long it take for them to get the interview? Okay, great question, Shabana Khan. Thank you for asking. So it really depends on which category you're in. So if you are in immediate relative category, once you are documentarily qualified, the immigrant visa is already available, and most of the times the interview is scheduled within 3 to 4 months after you're done with the NVC, just because there is some administrative processing for them to schedule the appointment and the availability of the appointment slots. And it obviously varies based on where the US Embassy is located. If it's located in a country where it's a little bit busier, then it might take a little bit more time. I've seen some cases take, with immediate relative category, take as long as 6 months. And I've seen even one case where it took 9 months to wait up for that immigrant interview, even though the immigrant visa was already available. But if you are in one of the family preference categories where you have to wait for the priority date to become current, for the immigrant visa to become available, in that situation, after becoming documentarily qualified, you still might wait for a year and a half, 2 years, even 2.5, possibly 3 years. So you're waiting for the availability of the immigrant visa first, and then you're waiting for the interview. So the best thing to do, if you want a little bit more details that pertain specifically more to your situation, let me know which category you're in and the priority date, and I might be able to give you a little bit more information. So 3 things: priority date, category, and then the chargeability area. And I didn't mention the chargeability earlier. Okay, let's move on to the next question from Yalunli 1786. Thank you for your video. I have a question. If my current immigration status or category is C8, pending asylum that is, should I just pick 999 alien awaiting decision on asylum? Yes, because there is no C8 in the category when I fill out online. Thank you. No, Yaluni, actually thank you for bringing this up. I think I actually had a question like this for online application. I don't know why they didn't add it, but yes, this right here, alien awaiting decision on the asylum, is the C8. I don't know what all of this stuff is. Weird, but yes, it is going to be the C8, so this is what you're going to be selecting. All right, moving further to the next comment from Pauline Liverpool Thomas 3809. I would just like to thank you for the advice given me in volume 32 and 33. Quite a long time ago, when we had request for evidence, which was late by almost a year. I am proud to say that both our I-130 and I-485 were approved yesterday. Thank you for your pertinent advice. Pauline, thank you very much for your comment. This is one of the probably, well, these are, I mean, I appreciate all the comments. Don't get me wrong. I appreciate all the questions and requests for assistance in certain things. It's just a blessing for me to be able to help some people. But knowing that after my advice was decent enough to help you with the situation and actually getting the approval, that is thank you. I really appreciate it. I appreciate this comment very much. Thank you very much, Pauline. All right, let's move on to the next one from Garish 87. Can brothers both age under 21 be part of the same application? Actually, no, wait. Both age under 21. Yeah. Be part of the same or over 21. Is it over 21 or no? That looks like under 21. I might be wrong. I'm really bad with math, so this would be part of it. So, can brothers be part of the same application for I-539 and I-539A? Yes, absolutely, 100%. Basically, as long as it's the family members, then it should be fine. You can do one application package. It doesn't matter. One of them is main I-539, and then the second, basically family member, whoever it is, I-539A. So yes. Okay, moving further to Shafali. I have one more question. I applied for my sister F4 back in February 2007, and I included her family too. Her kids were 10 and 11 at the time. Now they are over 21. My sister is still waiting to hear from NVC. What can we do to bring children the fastest way to USA? Shafali, thank you very much for your question, and I'm very sorry you're dealing with this. This is one of the most unfair things whenever it comes to I-130 family reunification petition is that there is this really high potential for children that are supposed to be derivative beneficiaries aging out. And Shafali, I would highly recommend you check out the video that I've just recently uploaded on this channel. Let's see if somebody commented on this. Maybe somebody commented so I can bring it up. No, nobody commented on it, unfortunately. It's called Understanding CSPA, basically, and it's a Child Status Protection Act. Understanding Child Status Protection Act, CSPA, and aging out in immigration whenever it comes to family reunification. And basically, there might still be a chance if everything happens, because you've been waiting. Let's take a look at the F4 category, because you've been waiting since February 2007. So let's see, February 2007, F4. Let's take a look at the graph A. So looks like people are getting with the I don't know why this is coming up. Why this is weird. Haven't had a problem like this, but looks like people who have the priority date in April 2007 As of right now, as of June, July 2023, their priority dates become current and they're getting their immigrant visas. So that means that your sister is really, really close. She has about, she's in February 2007, so she has about March, April, so like 2-3 more months for the availability of the immigrant visa. Now, let's see, since 2007, so in 2007, kids were 10 and 11. So now they gotta be, let me do my math. I have my calculator this time. So sorry, horrible math. 2007, so they were 11. Let's see, 2023 minus 2007. That is 16 years. So they are now 26, 27. So here's the thing. This is a family preference category. So the age of the children does not freeze once the I-130 is approved. However, thanks to the CSPA, you can subtract from their current age, 26, 27, you can subtract the amount of how long that I-130 petition was pending for. If this petition, and a lot of times for F4 category, they review it for quite a long time. They hold on to it for a long time at USCIS. If it has been pending for 5-6 years, you can subtract those 5-6 years for however long it was waiting. If it was pending only for 2 years, then yes, obviously you will subtract it from 26 from 27. It's still not enough of time to subtract to qualify them as children under CSPA. But if it was pending for 6-7 years with USCIS, that is, you can subtract it from their current age and it's going to bring them down to 2021. And that is enough under CSPA for them to qualify as derivative beneficiaries. So you see there is a little bit of a strange formula to it, but in some situations, and in your situation, you might potentially take advantage of the CSPA. So Shafali, I highly recommend finding that video on this channel. I uploaded it only like 2-3 days ago. It's fresh. It's called Understanding Child Status Protection Act, because your sister might be able to take advantage of it, and her kids might be able to come with her as derivative beneficiaries. So definitely check it out. And if that's not the case, if it's impossible to use that, then obviously the only way it would be to for your sister to get her immigrant visa to come here, and immediately once she comes in, because she comes in with a permanent residence, immediately file the petition for children to another family reunification petition, which it will be a long time to wait, because F is going to be, what is it, F2B category or F2A category, one of those two. But that would be the only way if they cannot take advantage of the CSPA. And the other thing that I wanted to mention about that Child Status Protection Act is that they have to be unmarried. That's another thing that kind of is a requirement to take advantage of that CSPA. But check out that video, and then if you have any follow-up questions about it, let me know and I'll try to address it. Okay, moving further to the next question from Galam Sowood. I am from Ethiopia. My case F21, so F2. My priority date July 28th. So wait a second, F21. So F21, that would be F21. So is it F2A or is it F2B? My priority date July 28, 2020. Documentarily qualified May 26, 2021. How much month NVC sent interview letter? Okay, so you're already documentarily qualified and your priority date is July 28, 2020. So I'm pretty sure F21 is the subcategory for the F2 second preference category, being the F2A, either the spouse, I think, or children under 21, but I'm pretty sure it's the spouse. That's how the NVC basically puts the subcategory, because for whatever reason, NVC, they have a little bit of a different, they use that subcategory, so it's a little bit different than looking at the visa bulletin. So let's take a look at the F2A. And September 2020, that's where immigrant visas are becoming available for people in the F2A category, and you are in July 2020, so you're already documentarily qualified, so you're literally looking at you're actually end of July. So let's see, this is the beginning of September. So you're pretty much August. So you're like 2 months away from the availability of the immigrant visa. I would give another 3 months for the scheduling of the interview. So I would say by the end of this year, most likely, very slim chance that it might take a little bit longer, and if the US Embassy in Ethiopia is busier than usual. But I would say by the end of this year, maybe possibly beginning of next year, you're gonna have your interview scheduled. Alrighty, let me post a response here. We're gonna move on to the next question comment from Ali EQ6CR. Please tell me how long to interview call. I am waiting 1 year. So Ali, let me know what the category is. So 3 things I need is the category. You can tell me where you're from, basically the chargeability area, and then the priority date. And I will be able to take a look at the visa bulletin. If it's a family preference category, or if it's immediate relative category, obviously then I will be able to give you estimates based on that. Okay, moving further to the next comment from Pazo MDJ. Hi, can I travel abroad before my green card expire? Yes, absolutely. If so, can I come back to the US after my green card has expired with the renewal application received? Yes, you can do that, but honestly, I wouldn't recommend doing that. Probably, if you want to play it safe, it's best to just renew the green card beforehand and get the renewed version of your actual physical card for traveling purposes, just to be on the safe side. Yes, you absolutely can, because it does give you for 2 years. And actually, let me read the comment. The receipt extends the validity for 2 years, so you already know that. So when I enter the information online, for example, to check in online to an airplane to get back to the US, do I need to enter the original expiration date, or should I add 2 years to the date? Thanks for your help. Okay, so you don't need to worry about the entering that information. You really don't enter the actual green card information, the permanent residence card, anywhere. When you're buying the tickets, when you're applying for visa to another country, you don't need. It's a permanent residence card is literally only when you're coming back to the United States. If you're a permanent resident, you're just showing it in the airport, saying, "There you go, I'm a permanent resident." And yes, it's completely fine. You can definitely show the receipt that you have submitted the application to renew your green card. It's not going to be a problem. If you want to play it super safe, which I would recommend, get all that renewal squared before traveling. But if you obviously cannot wait for the replacement of your new permanent resident card, then obviously you can just travel with the receipt and your old permanent resident card, and you still will be fine. But again, if you have extra time, I would recommend just safer the better, not taking an unnecessary risk. Okay, moving further to Sabir Hussein 3382. Hi, thanks for all your effort. Any help to guess when my interview will be scheduled? I am F3 from India and documentarily qualified on November 2022. My priority date was January 2009. All right, let's take a look at the visa bulletin. So India, they have a separate chargeability area. So for F3, we're going to be looking F3 right here. I cannot even select this now because this stuff is coming up. I don't know why is it AI prompt. I guess some kind of update from Opera browser. So F3, India is December 2008. The priority date, people with priority date in December 2008. As of June 2023, their immigrant visas are becoming available. So, Sabir, your priority date is January 2009. So that means that you are January 2009 and December, you're like 1 month away from the availability of the immigrant visa. Literally 1 month away, probably not even 1 month, because it's the end of December 22, and you are, I don't know when you are in January, but so you're like right there. It's around the corner. The availability of your immigrant visa is literally around the corner. So I would say give it another 3, possibly 4 months, because you still have the administrative processing with the U.S. Embassy, wherever it's located. It might take some time for them to schedule the interview. They might have it already scheduled, but they cannot send you the notice of when the interview is going to be up until the 30 days before the actual interview date, because they have to give you exactly 30 days to do the medical examination. You cannot do the medical examination earlier than 30 days, and that's why they scheduled 30 days in advance. So you possibly might be waiting another 3-4 months for the actual interview notice, but availability of your immigrant visa is like right now. Pretty much, it's almost there, so you're really close. And congratulations, that's great news. I mean, you've done all your waiting. You've been waiting since 2009, so it's very well deserved, you know, Sabir. You did a lot of waiting. Okay, let's move on to the next question from Jelena Vujic or Vujic 3290. Hi there, the beneficiary I'm applying for lives outside the US. He visited 3 times. Should I leave class of admission and I-94 blank, or still need to fill out? Okay, so if they are outside of the United States, then you're only filling out the information for when they visit the United States. When, you know, the current I-94, because they don't have currently a valid I-94 record, then you don't need to fill that out. Also, do I have to attach proof of other names used in the past, since all the documents of siblings relationship have the same last name? Thanks. Okay, so siblings have the same last name, but they have not changed the names, right? So if they have not changed the names, then that's it. You don't have to worry about that. But if there was a name change involved, then obviously, yes, you definitely do want to attach the proof of the name change. And most of the times it's, well, here, for example, in the United States, it's, you know, it's a core document, the name change petition, I think that's what it's called. If there was a name change. That's the only situation. Okay, so let me pause the response here, and we're gonna move on to the next question from Rathikarokaya7885. I missed my I-130 petition approved letter. Uh-oh, that's definitely not good. So most likely the I-130 petition approved letter, you're talking about the approval, the 797 form from USCIS. So if you have missed it, the physical mail, a lot of times whenever it comes to the NVC, which would be the next stage of the process, they send the emails. So if you have provided the email with your USCIS application, the I-130 petition, then make sure to stay on top of the email and check the spam folder, check the, you know, obviously the email every day, making sure that you don't miss the welcome letter, because the approval letter for I-130, it's an important, obviously, document. Of course, it's an approval letter after all. But you definitely don't want to miss a welcome letter from the NVC, because that is the next stage for you to complete, where you have to log into the NVC and start your documentary qualification process. So definitely don't miss that. Try not to miss that for sure. All right, let me post this and we're going to move on to the next one from Revit XOXO store. Thank you so much. You're the best. Nah, thank you. I doubt that I'm the best. Probably, definitely not. Actually, definitely not. But I appreciate your kind comment. I'm glad my information is helpful. Okay, moving further to the Snooty Fox 96. Still no update from USCIS regarding COVID vaccine mandate. Totally ridiculous that they dropped this requirement for everybody but green card. Yes, the Snooty Fox, you're 100% correct. Unfortunately, there is no update yet. I am personally checking it every day because, you know, I think I mentioned it quite often in these videos that I myself have an I-130 petition that is pending. And, you know, I am in general against all these mandates whenever it comes to, because if you think about it, I mean, besides the COVID vaccine that we have mandated right now for the, you know, as part of the medical examination, for the green card, for the permanent residence, there's also a whole list of whole bunch of other vaccinations. And I'm not really against vaccinations or anything like this, you know, don't get me wrong. But I am against this being mandated to people in exchange for status. You know, it's just not fair. Because why it's not fair? Because people coming here who are actually working towards getting that status, right? Doing everything legally, paying the fees, going through the background checks, and being in the country for years. You know, before I got my permanent residence, I was here for man, I was here for a long time. I was here for like 7, 8 years before I got my permanent residence. And after I got my permanent residence, I was here for 5 years before I got my naturalization. So to get my naturalization, it took me 13, 14 years, and before getting my permanent residence, I was living here for 7, 8 years. And obviously, I didn't have some of the vaccinations that I needed to get as part of the medical examination for permanent residence. So I'm here for 7, 8 years without these vaccinations and everything is fine. But to get my permanent residence, I now all of a sudden in 2 days have to get like 20 different vaccinations, which is, I know for a fact it's unhealthy. I mean, how can it be possibly healthy getting 20 different injections literally in the matter of 2 days? And I'm not making this up. This is what I went through in order to get my permanent residence. And this is what a lot of people are going through. Because if you don't have the vaccination record like myself, I didn't have the vaccination record from the country that I came from. I had to get all of them. So yes, and they do them within the span of 2 days. They inject like I think 5 or 7 injections, and each injection includes like a whole bunch of different vaccinations. It's really weird. Honestly, that just doesn't seem right to me, doesn't seem healthy to me. Honestly, if it was right now, I probably would have questioned. I would have questioned, should I get a permanent residence at all or not for that? But back then, it was too important for me, so I did it. Yes, I did suffer a little bit after that. I had actually my arm was pretty bad for some time. It was bad. But anyway, we're getting off topic. The point that I'm trying to make is that most people that are applying for permanent resident, they already live in the United States for years and years and years. So they have been living all this time in the United States, and now they're working for their permanent residence, and now all of a sudden they have to go through this crazy medical examination with a whole bunch of different vaccinations. Well, what's the point of it, right? And then of course there's the whole other group of people that doesn't do any of this, and they can still be in the United States and they can still remain here without any of that. So you see where this unfairness comes into play. It should be either this or that, either for everybody or for nobody. And obviously I would say for nobody, because it should be a personal choice. If you want to get a vaccination, you go to the hospital or whatever you go to get your vaccination, and if you believe in the power of the medicine, then good for you. I believe in power of our Heavenly Father, our God, and I don't need any of this man-made stuff that we think that is going to protect. But again, this is a whole different conversation. The point is, everybody should have their own choice, and right now there isn't really a choice, especially with the COVID vaccine requirement, because it's now only literally left for those people that are applying for permanent residence. Nobody else, literally nobody else nowhere has that requirement besides the people who are applying for permanent residence. And yes, it is not fair. And hopefully Congress, Department of Homeland Security, whoever will finally realize it and decide to get rid of it. But I would recommend everyone who agrees with me on this to reach out to your local elected officials and let them know that this mandate is still present for people applying for permanent residence, and they need to get rid of it. Send them a letter, be nice, be polite, but let them know that this is not good, this is not fair. Okay, moving further to Safali9. Hi there, I'm a US citizen. I applied for my sister in 2007 February and I got approval in 2008. And now waiting for her immigrant status. She lives in India. When I originally applied for her with family, it was her husband, and 2 minor kids, but her husband passed away and she's thinking of remarrying. In this case scenario, how can we update NVC? Also, will it be better if she remarry now? Shafali, I remember this question and I answered it in the previous volume. I'm gonna post it here. It was answered in 125, but now I understand what's going on, because earlier I read your comment and I was explaining you about the CSPA. So, speaking of the CSPA, you told me, you just answered my kind of a concern that I had. for only a year it was pending. So it was pending for only a year. So you can only subtract 1 year from the age of your sister's kids. So they're not gonna be unfortunately taking advantage of the CSPA. So the only thing that's left is for your sister to get her immigrant visa, come here, and as soon as she enters, she submits a new I-130 petition for her children. Unfortunately, that seems to be the only way to do it now that you told me that it's only 1 year. Okay, let me post 125 and 126 because there's both, because now I kind of understand what's going on with the situation. And let's address one more. Looks like, thank you, sir, for your information. Vanji Muleta, you're very welcome, Vanji. And Queen's Flashing 8190. Hi, my daughter NVC approved. How long for interview? Queen's Flashing, let me know 3 things and I will be able to give you some rough estimates. The category, the family preference category, if it's a family preference, you know, your daughter, so it's either F1 or it can be F2A, F2B, F3. So let me know which family preference category, or if it's an immediate relative, it's also possible. So let me know which category, let me know the priority date, and let me know the chargeability area, and I will be able to give you a little bit more information on this and give you some rough estimates. So thank you everyone for asking your questions today. Always appreciate it. It's always a blessing to receive these questions. Hopefully my answers were helpful to you. Thank you for your time. God bless, and I'll see you all in the next video.